All right, we're going to go ahead and get started. Welcome, everybody. My name is Anna Wexler. I'm an assistant professor of medical ethics and health policy. Martha is just outside the room and I'm about to say something about it. Yeah, there she goes. I want her to walk in. On in. I'm very pleased to welcome everybody to this inaugural Medical Ethics and Health Policy and MindCORE joint lecture series in Neuroscience and Society. This lecture came about in a moment of transition. As many of you know, last year, Dr. Martha Farah announced her retirement, and the Center for Neuroscience and Society, which she had directed for about 15 years, was going to be winding down. Martha had been in conversation with me and Dr. Joe Cable, professor of psychology and director of MindCORE, about which elements of the center's activities we might be able to sustain. And one idea that emerged was an interdisciplinary lecture series on neuroscience and society that would bring together our department, medical ethics and health policy, with MindCORE, and to bring together students and faculty from across Penn who might not otherwise find themselves in the same room. Joe and I were very enthusiastic about this idea, and it became the lecture series, or the lecture. Hopefully it'll be a series that you are here for today. And we do hope that this will be an annual series, one that carries forward the spirit of the Center for Neuroscience and Society, and really brings together an interdisciplinary community. We're very pleased to welcome Dr. Francis Shen as our inaugural speaker, which feels especially fitting since Dr. Shen attended the first neuroscience boot camp at Martha Center many years ago. I'm going to read Dr. Shen's formal bio in a moment. I just wanted to say a few words personally first. Dr. Shen is a man of many talents. He is an exceptional scholar. He's the kind of person where when he has published something, you're actually really excited to read it because you know it's going to be well written and very insightful. He's a dedicated mentor. I met him 10 or 15 years ago when I was just starting out as a graduate student. And I very distinctly remember him taking quite a bit of time to talk to me and offer career advice. I know that he has done the same for probably hundreds of students and trainees. He's also a competitive track and field athlete, not just in his college days, but he actually still competes. And in addition to running his lab, he's actually now running for political office too, as attorney of Hennepin County. Okay, now I'll get to the official bio. So Dr. Francis Shen is a professor of law, Solly Robbins Distinguished Research Fellow, and faculty member of the graduate program in neuroscience at the University of Minnesota. He's also Chief Innovation Officer for the MGH Center for Law, Brain, and Behavior at MGH. He directs the Shen Neurolaw Lab and has authored 4 books, including the first Law and Neuroscience Casebook and Brain Science for lawyers, judges, and policymakers. He has published articles on a very wide range of neurolaw and neuroethics topics, more than I can mention here. He is the founding director of the Dana Foundation Career Network in Neuroscience and Society. He co-leads the Neurotech Justice Accelerator at Mass General Brigham, a Dana Center initiative, and works on NIH Brain Initiative funded projects on portable MRI and community engagement in neuroimaging research. In 2021, he was awarded the Early Career Scholars Medal by the American Law Institute, one of 2 medals awarded every other year by the ALI for being a quote, pioneer in establishing the interdisciplinary field of law and neuroscience. He is also moving law and neuroscience into the real world as the country's first neurolaw candidate. Thank you for joining us, Dr. Shen, and I just want to give a very quick shout out to Jessica Marcus from MindCORE and Lisa Bailey from Medical Ethics for help organizing logistics for Dr. Shen's visit. So thank you, and please join me in welcoming Dr. Shen.
Very kind introduction. I want to start by being reciprocal and thanking Anna, Martha, Jessica, everyone for welcoming her, and many familiar faces who I haven't seen in a long time. So it's really wonderful to be here. And I want to start with Reckon back about a little over 10 years ago. I still have my shirt. I brought it with me. I didn't wear it. I told Martha I couldn't quite make it work with the suit, but Penn Neuroscience Boot Camp. This was the inaugural crew, and this was me playing with a head count. So it's really great to be here. My journey really started on this campus in many ways. It's where I first met my later mentor and co-author Owen Jones, and where I met many people who continue to be colleagues and friends today. So thank you, Martha, for bringing us together then and for continuing to bring us together now. No disclosures to make. I do want to acknowledge funders, both the NIH and especially the Dana Foundation. Anything I say is my own and doesn't necessarily represent their views. I put this here because I'll forget it. I'll get so excited, and there are a lot of trainees. And I love working with trainees. And if you're interested in anything I talk about today, or you don't like anything I talk about today, and you want to come yell at us, these are 3 places to go. The Neuroscience and Society, Career Network and Neuroscience and Society is specifically for trainees, and it's not just neuroscience and law, but neuro everything, neuromusic, neurophilosophy, neuroeconomics. We've got a neurosports thing coming up. The Neurotech Justice Accelerator is a really cool project that I co-lead with Teresa Williamson and Gabe Losser Munoz. Many of you know Gabe. He's a UPenn graduate. And this is important because we often hire. We actually have positions. And then the Center for Law, Brain, and Behavior is a place that I work a lot with, law and neuroscience. So I'll share these slides afterwards, but those are places you can go. So here's what I want to do today. It'll take about 45 minutes, and there'll be a little time for questions at the end, and then I'll stick around afterwards and we can talk. First, I want to really think about the future, and the question I will pose is whether Neurolaw is a field or a fad. I'll say briefly a little bit about what I do, and then give a past, present, and future. The past looking at what I think is some false starts, as well as where we currently are. The present with the focus on the challenge of individualization. What do we know about this particular individual's brain, the particular individual who has some legally relevant matters before us? Looking at the future with emphasis on neurotechnology and maybe what some of your roles might be in shaping that future. So let's start with this question. Is Neurolaw a field or a fad? And I think that's an open question right now. I'll give you an answer by the end, but let me preface it by sort of offering both roles. On one hand, it has the potential to be a field because I think the pillars of Neurolaw are super strong. The 2 pillars are simply this, and the whole of my career is based on this premise. On one hand, law is in the business of governing human behavior, and part of governing human behavior means that law is interested in mental stuff, both the mental states that people have as well as the mental processes that give way to decision-making and behavior that bring people in contact with the law, either the civil or criminal system. So pillar number 1 is the law cares about mental stuff. I mean, that's really, really basic. Pillar number 2 is that neuroscience tells us something about the way the mind works, the way we make decisions, the way we feel. And that's, again, really foundational. That's Neuro 101. That's high school neuroscience. That's grade school. And on Brain Awareness Week later this month, we'll talk about those things. So if those 2 pillars hold, then the basic idea is that this field of neuroscience, broadly defined, can tell us something about the way that the brain enables the mind and enables our mental states and our decision-making, and the law can learn from that and do its job of governing human behavior better. That's the basic premise. I think those are really strong foundations. And yet, and I know we can't be here today, we emailed about this, but I wanted to give an homage in this talk in particular to Professor Stephen Morse, who many of you know. Professor Morse is correct and has been correct for over a decade in saying that neuroscience currently has scant relevance, not just to juvenile delinquency and adult criminal justice, but basically everywhere. In the near to immediate term, it is not going to transform juvenile or adult criminal justice. Nonetheless, in the future, it may help rational reform of both systems. Here's another way to think about it. In 2007, Neurolaw made it to the cover of the New York Times Magazine. Often if you make it to the cover of the New York Times Magazine, that's like you hit payday. Finally, you've come out of the lab and into the real world, and then things skyrocket. Not so with Neurolaw. We are almost 20 years since that, and it's fair to say that the world of law has not been fundamentally transformed by neuroscience. Almost none of the University of Pennsylvania law student graduates will have encountered neuroscience in their careers as law students. It hasn't really changed. There are little pockets, and I'll talk about some of those, but it hasn't fundamentally changed legal doctrine and practice. Why? Something to think about in this talk, and I'll come back to that. Back in the early 2010s, I wrote a thing called Neuroscience 2.0, and I said, well, there are 3 things that could happen. One is we do such a horrible job that the whole field flatlines and no one ever publishes. There's never another case of neuroscience. Thankfully, the worst case scenario has not happened. But I said what could happen is that we become, and this is sort of a little academic cottage industry. And there'd be a little group of people who do Neurolaw, and they get together and they have their own little journal, but it never really takes off. Or it could look like this. We haven't had that yet. And so again, is neuroscience and law a field or a fad? Last thing I'll say, my last homage to Professor Morse, who's been a real hero of mine. He's written many things, and he used to start many of his talks by this quote: genetics may threaten privacy, kill autonomy, make society homogenous, and gut the concept of human nature, but neuroscience can do all of these things first. And Stephen would always say, not so fast, not yet. But even Professor Morse, pulled out of his articles, said there might be a case for modest optimism, and I think I'll try and make that case for you the rest of this. But you can decide for yourself. All right, what do we actually do? The motto of our lab is every story is a brain story. I firmly believe that. I will say there are two really important caveats. Caveat number one, every story is not just a brain story. It's not the idea that neuroscience and law push away all the other fields of inquiry. No, it's just that neuroscience might have a table at the legal decision-making round table. And the second is that every story is not a fully understood brain story. This turns out to be perhaps the major sticking point because we just don't know enough for the legally relevant questions we ask. Gratuitous picture of my brain, but it looks okay. And we do two things. So on one hand, and there are folks in this room who do both of these things as well, we think about how better understanding and better tools from neuroscience can be applied in the law, or maybe when they shouldn't be applied in the law, but also think about the arrow because law is in the business of governing neuroscience and neurotechnology development. There's a lot of ethics involved. How do you unleash the power of these new technologies while at the same time mitigating potential harms? And we've got experts in the room to think about that as well. We do all kind of work. I won't talk about most of it. I don't have time to talk about it, but we do empirical work, theoretical stuff, legal stuff. We do a lot of education and outreach. I've trained thousands of judges and with some other colleagues in this room as well. And I will talk at the end about our community engagement work. We do a lot of community engaged research. I spent a lot of time mentoring, which I love to do. I don't put everyone on my shoulders, but Craig was in our lab recently. I mentioned CLBB. I'll just mention what we do there, and the idea is that better decisions in line with science can produce better outcomes in line with justice. We do a lot of really concrete work. For instance, we work with the Suffolk County DA's office in Boston around an emerging adult program, which takes 18 to 25-year-olds and sort of science-informed program to try and divert them out of the main system. Mention the judicial training, and just so you know that this is happening, we spent a lot of time with judges. This was a year-long program with state judges in Massachusetts, where we actually did 2 overnight retreats with them, covered a lot of things that are front and center to their world. It's one of those pillars. They definitely care about brain stuff. Cannabis use, they wanted to know about addiction, mental health. They wanted to know about their own mental health and aging on the bench and much more. And every year, a bunch of judges, federal judges and probation and parole officers come to Harvard for a federal judicial center training. So a lot of stuff is happening. All right, so that's a little glimpse of what I do, but now let me get to the title of the talk, which is Past, Present, and Future. Neuroscience and law is not, contrary to some belief, a new thing. It's been around a long time, and wrote a piece on this, which I won't go through all the details, but the central question is whether we learn from this history. And I'll just give you a little glimpse of what that history looks like. So going all the way back to 1836, now this is more generally law and medicine, which has a long history, even before the 19th century. But the basic idea in this article was, hey, at least every practicing lawyer should have in their library the works above enumerated, all of these sorts of medical things. People were talking about free will and criminal responsibility in the 19th century. This is not a new set of questions. Even in the early 20th century, we're talking 1901 to 1940s, in the journal Brain, there are articles such as the relation of the lunacy laws to the treatment of insanity. And this stuff has been percolating for a long time. People have been, this is 1911, a manual for judges, like the latest criminal psychology. Physical basis of crime. This is 1913 we're talking about. So this is over 100 years ago. People had some sense of maybe the brain has something to do with with the law. There's been an exceedingly number long of these sorts of ads, just as a 100-year parallel in 1915. Do you know the knowledge which control your brain? And someone named Professor F.W. Foote was going to help you concentrate in 2015, and now in 2026, you can go online and get all sorts of the same nonsense. Just one more, because this is always funny. Have you a wrong way brain? But again, this is 1939. So the questions have been percolating. There are some real problems in law and neuroscience. I'll give you just a couple of examples, and we've got the man in the room. I'm not going to talk about book. I'm just using it as an example that we have really tried to think a lot about the anatomy of violence, the violent brain. But this also goes back 100 years now, the research about 100 years. And there have been some false starts. So this group will know. Egas Moniz wins a Nobel Prize for what? Somebody shout it out. Students? Yes, prefrontal lobotomy. Okay. So you may have known that. And this is the commemorative stamp that comes a little bit later. You might not have known that the law was really excited about this. In the Yale Law Journal in 1948, an article predicted that perfection of so relatively simple and inexpensive a technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals. Thankfully, it was never used widespread. It was used in some cases, but the idea sounds a lot like those two pillars that I started out at the beginning. Law is in the business of trying to modify human behavior, and it's the intractable problem. We can't solve violence. Science, do you have any help? Dr. Moniz shows up and says, yes, I do. And then the law says, well, we're not scientists, so do you have any, how do we know this is credible? Like, what are your bona fides? Well, I don't know. I have this one thing called a Nobel Prize. And yet even Nobel Prize winning science was not ready for use in the criminal law, which is a major challenge at this intersection. I don't have time to go into it. I'll just mention that in the 1970s and late 60s, Vernon, Mark, Frank Irvin, and others, these were at MGH and Harvard, so this is close to home, were pursuing surgery, psychosurgery for treating mental disorders, especially violence. They wrote a book called Violence in the Brain. It was on the cover of Fortune magazine. It's a great book called The Mind Stealers. And if you go and look at state laws, there are a lot of state laws around psychosurgery. Again, their basic idea was the same thing. Boy, we still haven't solved the violence issue, but we know it has something to do with the brain. And now we have a new solution. They did research with patients that would no longer be allowed under current ethics rules at MGH. They used stimulation. They wanted to, from the research, stimulate the amygdala, and then they were going to cut certain circuits and solve this problem. Again, thankfully, it wasn't ever used widespread. But there are multiple examples where neuroscience and the law has not helped. There's a wonderful book by our colleague Oliver Rollins, now at MIT, which I encourage you to look at if you're interested in this area, called Conviction, the Making and the Unmaking of the Violent Brain, which argues that neuroscience, far from helping, has actually hurt this discourse and this dialogue. So that's one challenge of the history. Here's the other challenge, and I'll make an analogy to AI. Anybody heard of this phrase, AI winter? Some have, some haven't. So the idea of AI winter is that things got really dark in the AI sphere. The promises weren't being met. Investors started to pull out, and you kind of had these dips. And this isn't exactly when they happened, but maybe something like that in the 80s, and again, a little bit later. Marvin Minsky predicted in 1961 we were on the threshold of an era that would be strongly influenced and perhaps dominated by intelligent problem-solving machines. I think he's accurately describing the world we live in today, but it wasn't the decades in between. And just a couple of the many headlines I'd love to go back through. This is, back in the 1984, truly automatic computers, threat only in movies, basically science fiction. This is from the 70s and from the 80s, things that are happening. Artificial intelligence, the next aim of computer study, consortium trying to build a computer that really thinks. But the 60s and the 70s and the 80s and the 90s, they're decades that are known for many, many things. They are not decades that are known for AI. All this stuff was happening, not behind the scenes entirely. These conferences are being held, but it didn't capture the public's imagination. This goes all the way back to 1967 predictions that we will substitute the intelligent machines for that of our brains. Again, these things were dismissed by many. They're happening. And Ray Kurzweil has a description I think is accurate. and useful for thinking about the role of neuroscience, the trajectory of neuroscience. About AI, he said the technology hype cycle for a paradigm shift typically starts with a period of unrealistic expectations. And while the widespread expectations for the revolutionary change are accurate, they're incorrectly timed. When the prospects do not quickly pan out, a period of disillusionment sets in. And those are those AI winters. I think we're probably in a Neurolaw winter right now. Cover the New York Times Magazine in 2007. There's a lot of work in the early 2000s, maybe up to the early 2010s. There were these previous periods that I've kind of hinted at where, oh yeah, everything's going to have Nobel Prize for the prefrontal lobotomy. This is going to be a major contribution to the cure of criminals. We got it. No, we don't. Right now, Neurolaw, what is the state of the field? It is rarely taught in law schools. We have a case book, but it's used by some, but rarely. Neurolaw, I can tell you from being out in the public every day talking about neuroscience and law, no one's heard of it, even attorneys. And until this day, I don't know if, especially the trainees, if you've ever heard of Neurolaw or seen any examples, right? So it's really new. And again, the question is, where is it going next? All right, so keep that in mind. I'll just close this little segment by saying that here's the punchline from Kurzweil. So there's, period of disillusionment. Nevertheless, exponential growth continues unabated, and years later, a more mature and realistic transformation does take place. And I would say, see the world of AI that we live in right now. It didn't come out of nowhere, but it was, an exponential. If it's easier to see growth in a linear curve, because every year we're getting a little better. Right, those exponential curves, like, is anything really happening? And then, right, it goes up like that. Okay, so that's where we stand. Why hasn't Neurolaw fulfilled its potential? What does it need to go high? Individualized knowledge that's actionable and precise. I'll talk about addiction in a second. It's a good example. Decades and decades and decades of neuroscience, including neuroimaging research on addiction. And yet neurobiology is not a part of the diagnosis of substance use disorder. If any of you or your family members or anyone you know has been challenged, they didn't get a brain scan to get their diagnosis. Now there's pharmacology involved, and so that's mattered. But rather than just understanding the circuits, we need to say, okay, what will work for this individual person, especially for the law? How can you help us? All right, so let's talk about that individualization challenge. And let me talk to you a little bit about what actually is happening in courtrooms and in the areas. Now, one thing I'll say is that we'll bridge to 15 years ago. We sent out our course book. This is with Professor Owen Jones and Jeffrey Shaw, neuroscientist and law professor, the Law and Neuroscience course book. And when you send out a book, of course, the publisher has to send it to the reviewers, and the reviewers will say, hey, this is a good thing, this is a bad thing. And this is a review that motivates me to this day. I'll share it with you. The reviewer said, well, there's just one concern. Basically, your book's going to suck. The topics are so hypothetical and conjectural that most students find the course impractical. Most professors are left wondering what, if anything, neuroscience can ever say that's truly useful to the law. So this reviewer, who I don't know who it was, would be in the fad camp. And I've worked really hard, and I think our field has, to try and find ways that are not hypothetical, conjectural. And I can tell you that as a matter of description, there are hundreds, there are thousands of cases where neuroscience is and has used. Moreover, the field is moving really fast. The first edition we published in 2014, the next edition in 2020, we're working on the third edition. Almost 50% of the material in that 6 years between first and second edition were new. The neuroscience hadn't been discovered, the cases hadn't been resolved, and the interstitial tissue, the commentary, the work that happens on this campus connecting them had not been developed. And 90% of the material, even in the first book, was only since the year 2000, which is when I graduated college. This stuff is really new, and our third edition will have lots and lots of new stuff as well. Why is there all this new stuff? Because a lot in law hinges on how brains work. If we had more time, we could talk about memory in the law, brain death, brain injury, emotional decision-making, my favorite topic, lie detection, adolescent aging brains. I'm going to touch on just a couple of these, but there's a lot there. We cover a lot of these things if you want to come to Neurolaw Bootcamp as well. Okay, one thing I want to start with is that a lot of the academic work has focused on criminal law stuff. Did my brain make me do it? The vast majority of neurolaw cases and the origins of modern neurolaw are on the civil side. How are they typically used? In brain injury litigation cases, someone is injured in a car crash and is litigating with their insurance company. The insurance company says, "Oh, you're not so injured." And they say, "Yes, I am. And I'm going to use my experts in various fields, including neurology, and my scans to show that I'm injured." There are thousands of Social Security disability benefits cases that get litigated. Similar thing. It is much more than criminal law. The term neurolaw started from an attorney named Sherrod Taylor, who is someone I've met. He's based in Kansas City, retired for many years now. And he started the Neurolaw letter. This was pre-internet days, friends, when you had to print this stuff out, and then he would mail it. And I'm going to show you something that you've probably never seen before. Some generations will recognize this. How did they teach Neurolaw? There was no Zoom. There were no CDs. There were cassette tapes. So he shared this with me for the book I'm writing, An Introduction to Neurolaw. There they are. They would send this out, and they would send these things out to thousands of people. They are personal injury lawyers. That is how this field really got started, litigating brain injury claims, claims that had not previously been even considered brain injuries, but now they were. I could talk more about it, but we don't have time. I will say that there are few cases, and there's some work trying to look at this distinction between physical and mental. Neuroscience can offer both individualized information, but it can also conceptual information. And one of the concepts that the law really struggles with is how to handle mental stuff. For insurance law, mental health parity, do you get the same coverage for a broken leg as for some sort of recovery from mental trauma? And this came to a head in a case in Michigan. This is a good teaching case, Allen v. Bloomfield Hills. The case involves a train conductor named Charles Allen. And this isn't a picture of the actual train and bus, but it accurately sort of shows what happened. Bloomfield Hills is a city in a beautiful suburb outside of Michigan. And one morning, it's actually winter, so it'd be a little more snow on the ground. The train is coming down. Charles Allen is conducting the train. And for whatever reasons, although the crossing guard gate comes down like ding, 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 this school bus swerves and tries to beat the train. Charles Allen sees this, panics, does everything he can to try and stop the train, but he can't. Now, a train hits a bus, the train wins. Thankfully, there are no kids on the bus, but the bus driver is seriously injured. Mr. Allen gets out, runs like 800 meters down in the winter, sees this, and fast forward, develops post-traumatic stress disorder. Often it's hard to know what causes PTSD. There are so many different causes. In this case, there was rough consensus that one, he had the PTSD, and two, it was caused by this very traumatic accident. So he's unable to work after this. He had always said this was one of his worst nightmares as a train conductor. And so he sues the city of Bloomfield Hills because he can't work. The problem is he comes up, lawyers will recognize this, there is a clause, this is kind of standard for government immunity in most places. Government agencies shall be liable for bodily injury and property damage resulting from negligent operation. So if he had been Mr. Allen walking by and the bus hit his leg and broke his femur, no problem. He can sue. That's bodily injury. But remember, he is in this train caboose. He doesn't have a scratch on his body. So is his PTSD a physical bodily injury? Well, he says, yes, it is. And he finds a neuroscientist who's going to use PET imaging to try and support his claim. The district court says, no way. We have never said that PTSD without quote unquote physical manifestations is a bodily injury. No way. But he appeals. And the appellate court says, wait a second, we see the logic of your argument. The brain is a part of the body. PTSD is instantiated in the brain. Like, where else could it be? Therefore, this is a bodily injury. It goes up to the Michigan Supreme Court. By this point, it's drawn a lot of attention. As you can imagine, the plaintiff's lawyers, they file an amicus brief. That's a friend of the court brief. They're very interested in this. The insurance company is very interested in this because there's a slippery slope problem. If PTSD is a bodily injury, what about every other mental disorder? And of course, that was just the point. It's settled on the eve of the case. So there's no precedent in Michigan, but these sorts of questions emerge. And it's one of the places where neuroscience and law intersect, not just in resolving individual cases, but thinking carefully about the doctrine and the insights that neuroscience gives. And I can tell you, again, just being in the community a lot, that the idea that our mental life is facilitated by a physical brain is a foreign concept to most of our friends in this city and across the globe. I've been, it's a really good reminder that, in this zone, oh yeah, the brain facilitates mental life, that the brain has something to do with our deepest desires and decision-making. That's a really, it's a bridge that I think many folks are not yet crossing, and that the law is very hesitant to cross, but it's an area. Another area of neuroscience and law, and cite to Dr. Wexler, is the governance of neuroscience, both the governance of neuroscience research, what can you and can you not do, and this is happening again at the federal level, but also what sorts of technology should and should not be on the market and with what precautions. Those are all both ethics, but law as well. And that's an area of neurolaw. I mentioned the addicted brain. It's one of the illustrative examples. I'm not going to talk about do we have free will, but there are many cases in which some flavor of that question is showing up. And the case I'll talk to you is about a case named Julie Eldred, but I want to mention before that neuroscience has had a major role in treatment. So we don't talk enough about pharmacology and neuroscience and law. I'll mention that at the end. But it's used all over the place. In criminal sentencing, science of addiction has shown up, but it's also been the possibility of doctrinal change has come up, and this is a case that illustrates that. So this is a picture of Julie Eldred, and she's been very public about her case, as is her lawyer, and we've done programs with her lawyer about this case. Her basic facts with this is a case that emerged in the mid-late 2010s in Massachusetts. Miss Eldred had an addiction to opioids. And to fuel that addiction, she stole an amount of about $250. So she comes in the district court and gets probation. And you don't have to be a lawyer to probably figure out what the number one condition of a drug-related offense is: probation condition. Don't use. But if you know addiction and the way it works, you also won't be surprised to know that she relapsed 10 days later. At that point, there weren't beds left, and so she was briefly incarcerated, and she filed a challenge this on the grounds that it was unconstitutional under the Massachusetts and also the federal, but especially the Massachusetts state constitution, to require her to remain drug-free, because as an addict, she had no choice as to remain drug-free or not. So how can you require me to do something that I don't have a choice to do? This went up to the Massachusetts Supreme Judicial Court. There were lots of briefings on both sides, a lot of neuroscience. Ultimately, they ruled against her, both procedural grounds, some doctrinal grounds, but these sorts of questions are emerging. We'll probably see more of them. Some questions that you might want to know: can brain evidence persuade judges? The answer is yes. Also in Massachusetts, this is in the context of juvenile and emerging adult justice. There's a major case from 2024 called Mattis. Two colleagues of mine testified, and go up to here. Here it is. Dr. Galvan, Adriana Galvan, who's at UCLA, Dr. Robert Pinchriff at Mass General Hospital. They testified, and the court decided that as a matter of state constitutional law, it would no longer be constitutional to allow life without the possibility of parole for 18, 19, and 20-year-olds. Massive change in the law, and the briefs were heavy on neuroscience. These were the two main experts. They are both heavy on neuroscience. This illustrates the difference between level change and policy change versus individualized change. That's been a real point of contestation in juvenile justice cases where neuroscience has been used a lot. It's been cited by the Supreme Court in changing the sentencing parameters around adolescents. But it's still unclear whether and how scientific knowledge about adolescent brain development can or should be used in individualized cases. And this is largely because the way these cases go is there's a 17-year-old and the public defender or the defense attorney says at sentencing, Your Honor, we know that the brains are still developing at 17, and therefore my client needs to have a lesser sentence. The problem is that, yes, on average, 17-year-olds are different, both behaviorally and neurologically, than, say, 45-year-olds. But what about this one particular individual who did certain things that other adolescents may not have done? It's really an area of great debate. Group level advocacy may be more appropriate, and it's been happening. I could give you hundreds more cases there. I won't, because I want to give you a couple more and then talk about the future and save some time for questions. So a question that you might ask is, well, does it matter at all? Can brain evidence persuade jurors? Is this just, an academic enterprise? The scholarly literature on this question is still open for debate. It's hard to do mock jury studies for a lot of reasons. And the case law is just hard to compile. So we've got anecdotes. Anecdotes are what they are, but this is a pretty powerful one. It's the case of someone named Grady Nelson. I write a lot about it. And this is a case in 2010. This is Mr. Nelson. And he was convicted, and there was no question about the guilt phase, of multiple crimes, including stabbing his wife 60 times and slashing her throat, sexually assaulting and trying to kill his stepchildren. He had a rap list a mile long, including prior conviction, including rape of a minor. And his attorney, Terry Lenneman, knew, this is Florida, death penalty state, knew from the beginning that this is all going to be about, does he get life without the possibility of parole, or does he get the death penalty? And his attorney, Attorney Lenneman, brought in an expert named Robert Thatcher, who brought out quantitative electroencephalography evidence, a so-called brain map. And he argued that because of fetal alcohol syndrome and a number of other things, and Mr. Nelson did have a horrible childhood, in the words of his lawyer, not the expert, his lawyer said, "Ladies and gentlemen of the jury, my client has a broken brain. It does not excuse his actions, but it explains them." So the jury hears all of this. One of the interesting things about this case, and I've sat down with Attorney Lenneman and talked with him about it, and he's published, he said, he does a lot of death penalty cases. And he was bringing out all of his usual traditional types of evidence to try and do mitigation. The childhood issues, this one thing and another. And he said, he's a trial attorney, he said, it wasn't clicking. I could see the jury wasn't with me. But when I got to the brain evidence, that made a big difference. The jury, to set it up, and I'll give you the punchline, is 12 people on the jury. At this time, a simple majority in Florida was needed to go to death row. So 7-5 death row, 6-6 or less, life without the possibility of parole. That jury came back 6-6. They spared Mr. Nelson's life. And after the case, 3 of the jurors spoke with the Miami Daily Herald. You may or may not know this. If you serve on a jury, you don't have to talk with anyone about your experience afterwards, but you're allowed to. You can write a book about it. You can talk with the newspapers. 3 of them did. And in their own words, here's what they said after seeing this evidence. Juror Dolores Cannon, hospital secretary. When the brain evidence came in, the facts about the QEEG, some of us changed our mind. Juror John Howard, airport fleet services worker. The evidence turned my decision all the way around. The technology really swayed me. After seeing the brain scans, I was convinced this guy had some sort of brain problem. They didn't all buy it. Juror Leon Benbow, retired mailman. All that scientific testimony, that was a waste of taxpayer money. That's phony. There's nothing wrong with that guy's brain. And I'm on record with colleagues Shaw and Jones as really being very critical of this type of evidence and having it admitted. But this is the case I start my classes with. Because if we take them at their word, and I don't see a reason not to, we have a case where a man's life was spared on the basis of neuroscience evidence. And yet this neuroscience evidence, like the experts, all the rest of the experts, including the American Academy of Neurology, say, no, this should not be used for these purposes. So is this a misuse of the science? Or is this a great use of the science? I leave that for you to think about. But either way, it's evidence that this stuff can matter. All right, to sum up, if I had more time, I'd tell you more about this. No, we don't know enough about the neurobiology of interpersonal violence to establish causal links. No, neuroscience can't tell us exactly what a criminal defendant's mental state was at the crime. No, we don't have a painometer. No, we don't have a great solution for the group to individual problem. No, DSM-5 doesn't have brain biomarkers yet. We'll see if DSM-6 does, probably not a lot. And no, we don't have, a brain-based lie detection. It's been a decade of sort of, no, not ready. No, not yet. And yet, I'm still pretty excited about the future. Why is that? Well, here's why. There are a lot of law and fields, law and economics, law and philosophy, law and history. And the basic idea with all of those fields is that knowledge from those other fields can help the law do its job. So law is thinking about, should we raise interest rates? Well, let's talk with the economists to figure out what would be the likely impact of raising interest rates. How would that affect us? They give us new knowledge. And one of the things that neuroscience does is give us new knowledge. But what I think separates neuroscience and law, or at least makes me hopeful for the future, is that neuroscience also gives us new tools for modifying the way that we process information. course, the tool that we've had for decades are drugs, which are really important. There are additional new types of drugs and new tools coming, and this generates new types of evidence. So my prediction is that advances in the brain sciences, which will never be perfect, and new technologies to modify those relationships will eventually galvanize what I think will be revolutionary changes in doctrine and practice, the stuff that hasn't happened yet. But progress will be halting and slow. Why? Because individualization is difficult, and just this thing is so darn complex. And Dr. Wexler and I were talking earlier about how complex it is, and I'm very amenable to the critique that just too complex, and maybe some of these are. We've been trying for a long time. This was from the 1950s. I love this cartoon. I loved it most in 2016, but I still like it. That humans' intelligence and intellect will be able to be increased by drugs and by linking human brains directly to computers. Okay, this stuff is starting to happen. 7 years ago now, we ran a program called Computational Justice, how AI and digital phenotyping can advance social good. And at that time, it's like, hey, in the future, we're going to use brain and behavior data being measured via smart technologies. Well, no, of course, that's already happening. That's almost old news at this point. One of the things that's going to be really exciting and important for research and then for clinical use and then for the law is that we're going to bust out of the lab and out of the hospitals and campus. So right now, if you want mental health treatment, you have to change the lock. You traditionally had to go to the provider. Now, provider and technology comes to you. And I want to talk about one particular project that we've been working on for years around portable MRI. So technologies become smaller and smaller and more portable. And we've been working with a number of colleagues around the ethics and legal implications of taking MRI, and these are prototypes. That's in the market. There may be one. Jeff, is there one here already? Do you guys have it in the system? Yeah. Okay, it's one on campus. There's only one that exists in Minnesota, but it might be coming. There are other prototypes. And the basic idea is that can we image outside of the lab, and what types of new technologies might enable that? You change the field, you lose some of the resolution. There are downsides, but this stuff is happening, and you can go into the community. And so this video I'm going to show you is us in Boston, the streets of Boston, scanning ourselves, and we did some scanning with community members. You can just start to think of all the ethical issues that emerge when you start showing up and scanning on the street instead of scanning in an environment. Neuroscientist, Alzheimer's specialist. The same thing, you use a snowblower. There are my scans for anybody to see right there. You can hear other people talking in the background. Data privacy. All right, so I'm all smiles there, but you can imagine some real misuse. Say research misuse, that was something we're really concerned about. Scan and go away. So we're just going to scan in the community and then drive away. We're going to ignore incidental findings. The reason I was interested in this project is that it has potential legal implications. It is really, really hard, often near impossible, to get a brain scan for a legal client, even if you think they might need it. Maybe this sort of future and many others will be opened up. And you can learn more about our work in neuroimaging ethics. Just one other of the many new technologies I want to mention, and Dr. Wexler and I were talking about this earlier, there's more and more deep brain stimulation, more and more implants. We are moving from a world of wearables to implantables, and that will generate a new type of evidence what we call deep brain evidence. Almost every legal case involving neuroscience and law that I could talk to you about today that's happened has involved collecting brain data after the legally relevant behavior. Maybe before if there was something in the clinical record, but never at the time of the legally relevant behavior. That will change because there will be more and more people, there are hundreds of thousands of now, walking around with 24/7 sensing devices implanted in their brain. Elon Musk has called Neuralink, he wants to make it Fitbit for your brain. Well, there are legal cases where Fitbit evidence has been used. Defendant says, I was sleeping at the time of the crime. Let's check your Fitbit data. So our example here is A crashes into B and driver A says, I was totally paying attention. I was totally concentrating. Maybe that brain data corroborates or doesn't corroborate. There are a lot of other ways. These are going to be really, I think, interesting questions as we show up. I wish I had more time to talk about lie detection, which I think is the holy grail of law, neuroscience, and neuroethics. And I think there ought to be a massive investment in it. And I will also mention that neuroscience in the law can be very important, even if it's not very frequent. Instant replay, if you're familiar with sports, you probably are, is almost never used. Almost every play and across all sports does involve instant replay. And yet, instant replay is tremendously important. Why? Because it's used in high stakes questions. Did they score a touchdown or not? Where you can't tell from the regular information you have if it works. Like they're all the humans, but we can't tell if the foot was on the line. Neuroscience will have its biggest purchase where the behavioral data doesn't do what we need it to do. But we can look under the hood. All right, so the trajectory, the future of law and neuroscience. Is Neurolaw a field or a fad? I'll hedge. Say Neurolaw is a field of the future. I don't think it's entirely a field yet. I think it's headed that way. My answer to this is the following. So one is there just needs to be better science and technology. I mean, that's just the case. We wait for neuroscience to help us out, and broadly defined, lots of other fields. We need more investment. I want to make this point because it's an important one. In some ways, it's amazing that Neurolaw exists at all because there's been virtually no investment in legally relevant neuroscience research. What do I mean by that? So there are neuroscience advances, and almost all of them are designed, almost all of the grants you're applying for, you're not saying, I want to do this research because I'm going to improve the law. You're saying, I want to do this research for health, some version of health or basic science. This is where almost all the funding is. There is virtually no funding where someone says, the main reason I want to do this funding is for a legally relevant purpose. Neuroscience and lie detection is one, and there hasn't been major funding with a few exceptions since the 2010s, which means that at present, we take stuff that was developed for something else and bring it into the law. And that's a real challenge. All right, third thing, we ignore too much the civil context, and we should be doing more of that. I mentioned we need stronger work with pharmacology. The field has been way too US-centric. This has been changing, and thankfully so. Neuroscience and law is relevant to all legal systems across the globe, but how it's relevant will be very different. Our field is too fragmented, so FDA regulation of neurotech is just as much neurolaw as did my brain make me do it, but we don't get in the same room enough. We have no architecture for training the next generation. I get emails every day from students who are interested. Well, there is no Law and Neuroscience Society. There is no annual conference of law and neuroscience. The postdoc in law and neuroscience that I did in 2011 went away, and we didn't have a postdoc dedicated to law and neuroscience as a program until this new Dana Foundation Neurotech Justice Grant a year and a half ago. So we're also too isolated from communities outside of academia. Now, one cool thing is that although number one, we have to wait, that is those of us in law, we can do everything else right now. We can build an architecture that is ready for the potential for some sort of growth that looks like this. And I hope we'll do that. And I hope that when we do that, we're really engaged with community. Like I said, we're out in the community a bunch. We work, for instance, with a group in Boston. It's this amazing social enterprise group. They run a bookstore. They work with youth 16 to 24. They're called More Than Words. And we engage them around our emerging adult program around neurotechnology. I think that's really important. So here are the last couple slides. We'll take a couple questions. Neurolaw, field or a fad? Neurolaw, I suggest to you, is a field of the future, but maybe the future will be here soon. And I'll leave it at that, except to say you can contact me to get involved and we can take some questions. Okay. Questions, thoughts? Yes.
Hi. Thanks for your talk. Super interesting. I am one of the postdocs in the department. I work in reproductive medicine, ethics, but something I was thinking about that maybe intersects is personhood debates. Even in debates around fetal personhood and embryo personhood, there's sometimes an emphasis on like measuring physiologically like when things begin, but then also thinking about end of life. Is there a possibility where neuroscience is used in different ways to think about when personhood begins and ends and who should be afforded personhood rights based on the brain? If that makes sense, like that to me seems like as we have more information about how brains work, that could affect how we treat and think about and legislate and personhood issues.
Yeah, it's a great question. So the answer is it's already happening. My view is that neuroscience or any other field outside of, law can inform the law around personhood and rights and responsibilities, but are not dispositive. But to your point, in the briefs around the termination of pregnancy cases, the neuroscience of pain has been brought up, and there have been debates about whether that was appropriate or not. At end of life, we were actually talking earlier today, Dr. Gary and I, about research around covert consciousness and the idea that some of those in a comatose state may be it's such that their person still exists. They're still alive there in ways that are legally and ethically meaningful. And maybe that's a place where neuroscience can help because the behavioral evidence we can't tell. What's interesting, I think, about all of the ones that this personhood example is that they do fit in the bucket of, hey, do you need neuroscience? Do you need to open up the hood? Or can we just work with behavior? So by contrast, some of the debates around juvenile justice, you don't need neuroscience to tell us that 17-year-olds are different than 60-year-olds. It's just we can see that. But in all the examples you've just raised, we don't know exactly what's going on. And just opening up the hood and looking at what's happening either at a group level in the brain, does that potentially inform our decisions? It already is. Whether it's right or wrong is for an ethics debate. But I think you're right that these things will track. And I'll add one more, which is that it's also a hot topic in rights for non-human animals. There are different ways to justify rights for non-human animals, but one of the tracks involves cognitive ability or something like that, and whether or not they should have legal personhood. So these have been cases around great apes and others where legal personhood is a term of art to mean in the eyes of the law, you're going to have some bundle of rights and or responsibilities that the law will recognize. The basis for those can vary a lot. Some of them have nothing to do with cognition, but some of them do. And the most recent example are some of the most recent examples are around organoids and also AI systems. And the analogy that some make as well, if you're going to use something along a cognition-based assessment of what constitutes personhood, it is someone deserves personhood, something deserves personhood because of the way that they process information, that they can feel or they can reason or whatever it is, they can make decisions. Then maybe some have argued some AI systems should fall in that bucket as well. So I think it's a great set of questions, very contested. I don't think that neuroscience offers answers, but I think that neuroscience offers information that will be used in these debates and already is. Yeah. Yes.
So you think that like neurolaw is a career or a field in the future. So I'm asking more about like, what do you think like a career in neurolaw would look like? Are they going to take the place of the experts that go into courtrooms and advocate for certain brain states or not? Or where do they fit in actually?
Right now, there is no good career in neurolaw. That's what I tell students all the time. But the other thing I say is that neurolaw at present is probably never going to be on the business card, but might be a part of the work. So, for example, defense attorneys who have young adults in their client base. Many of them are thinking about, probably most are thinking about, and many of them are utilizing, maybe not effectively or appropriately always, but some version of neuroscience. So the job description, if you search for neurolawyer, would show up, but it turns out that they're actually using that. Certainly, the one exception is brain injury litigation, where it is explicitly neuroscience and law. So there's going to be a smaller subset where, okay, a lot of the cases pretty clearly involve something around the brain. I think the broader context will be in the ways that law and economics is not an area of practice as much as it is a lens by which you enhance or modify your practice. And so understanding something about law and economics can be really effective, really appropriate in a lot of areas of legal practice. And I think its bigger impact will be in that zone where this becomes something that helps us understand each other. So even in client-attorney relationships, and I'd say even familiar relationships, I think addiction science is a pretty good example. Even if the science isn't good enough to appropriately treat someone's addiction, sometimes just knowing and naming it can be really helpful for being empathetic. And it doesn't mean that if, this family member's got the addiction, you're going to maybe leave your kids with them for the weekend, but it does mean that when they're a little more erratic, at least there's some understanding. And I suspect that would be a part of it also. And then there's a whole world of the regulatory side where I think not just neuroscience, but a whole bunch of these areas are going to be cutting edge, and it's going to be really important for lawyers to understand them. Yeah, I guess.
I was wondering about how you see the presence of neuroscience within legislation currently, especially I guess because in the past decade, mental health has become a bigger question, and addiction that has been reframed as a disease. So just wondering how you see neuroscience here.
Oh, what a great question. And I didn't plant it, but it's great because I wrote a whole really long piece on neurolegislation. And one of the arguments, I love your question, is that most of modern law, it's been said we live in the age of statutes. Traditionally, law, going back centuries, was not made by legislatures, but was made through case law by judges. But now, almost everything goes through legislature, state legislatures, city councils, federal government, they can never get anything done. And there is more and more use of neuroscience in legislatures. And so right now there are active bills, for instance, and some have been passed in Colorado and California and elsewhere around neural rights and around data privacy. One of the interesting things I found that I think remains true is that I asked the question, would neuroscience transform legislators and sort of change the way that they're oriented? Or would they come in with their preset set of policies and positions, and they would just use neuroscience when they found it effective and convenient? And my evidence suggested, and we haven't redone the study, but I think we'd find the same thing. For the most part, neuroscience was used to support sort of pre-existing policy positions rather than, I see the world differently. I'm not sure that entirely will be the case going forward, but I think it's really important. Mental health has been an area. There's other areas that we saw, a lot of them related to health, so funding, but also places like, say, driving. And I didn't talk about the aging brain, which is an area that our lab focuses on a lot, but trying to think about how we come to grips with an aging society, also really young, like education work, so the work of neuroplasticity being used in bills related to funding for universal pre-K is a concrete example. So yeah, there's a lot of work in that space going on. And one of the questions I raised there is, what is an appropriate legislative use of neuroscience? Because when you talk in the public sphere, I know a lot of you have an interest in sort of doing the really rigorous research and bringing that research in the community. No one is reading your PubMed articles in the community, right? And so you have to change the way you talk. But if you change it too much, then you've moved away from the lab science. And so there is this challenge of communicating and engaging in ways that still stays true to the core science, but is also accessible and meaningful and effective at changing the policies in the way you want to. So great question. We're at time. Yeah. Okay. I'll stick around just informally if anyone wants to stop.
Please join me in thanking Dr. Shen.